Hello, my name is Sherry. I'm making this video because I read some disturbing information on a website. On this site, Their Dirty Little Secret, usgovconspiracy.com, the Johnson family exposes corruption in the probate court of Eastern Missouri 8th Circuit in St. Louis, Missouri. The Johnsons have agreed to talk to me about their case. At this time, I'd like to introduce Jeffrey Johnson, who is the estate executor, Joseph Johnson, the legal proxy for the estate, and David Johnson, the investigator for the estate. Let me start with you first, Jeffrey, and get the background of your case. How long have you been seeking justice in the court system?
But this case is a 25-year-old case that stems in the Eastern District of Missouri of the 8th Circuit in the probate division. And it began in 1987, the death of our father, P.D. Johnson. Our mother, Vandelia Johnson, was the personal administrator over the estate of her husband. On March 3rd, 1988, the administrator died a suspicious death in the St. Louis University Hospital located on Vista Avenue here in St. Louis. And what made it so suspicious was that Dr. Donati and Dr. Hess had previously told the members of the family that they didn't know what the cause of death was. In the process, the city coroner of St. Louis, which was Dr. Graham at that time, was not summoned to the hospital, who was in charge of investigating suspicious deaths. On top of that, the hospital stole the administrator's brain during an autopsy to conceal the actual cause of the death. At the death of the personal representative, my brothers and we began to investigate why our mother never received her husband's estate. And at that time, we uncovered in the probate division that probate judge Nicholson, as well as the estate's attorney, Julius Baird and Associates, had committed a theft of money from the estate. When we confronted the estate's lawyers, that they said that we could fire them, but that wasn't going to happen. So they proceeded to try to separate themselves from the theft of the estate by going to Judge Nicholson, Judge Thomas O'Shea, and they wanted to change a judge, and they wanted to withdraw, and they wanted the estate to pay them for their services. At that time, they were granted an illegal change of judge to the circuit court, to Circuit Judge Brandon B. Ryan, who allowed them to go judge shopping for a minute, according to the record, but ended up back into Judge Brandon Ryan's court, where he so ordered the motion for them to withdraw, and he so ordered us to pay the estate of P.D. Johnson to pay Julius Baird and Associates.
Okay, have you notified the news media about your concerns and findings? Because after all, a free press is the cornerstone of a democracy.
Yes, over the 25-year period beginning back to 1988, we notified several news agencies, as well as previously we have notified actually the same news agencies. We notified Channel 2, 4, and 5 of our local stations here in St. Louis. We contacted Chris Matthews of Hardball of MSNBC, Al Sharpton of MSNBC, Good Morning Joe of MSNBC, as well as Fox News. We contacted the Congressional Black Caucus as well as the NAACP on this matter, but to no avail, we haven't got any responses. But I would like to say, in my summaring this up, is that we often hear the President of the United States speaks about playing by the same rules regarding to the rich paying their fair taxes. But playing by the same rules shouldn't just apply to taxes, but it should apply to all three branches of our government as well: the executive, legislative, and judiciary, as well as the Supreme Court and the news media of this country, because none plays by the same rules. And in closing, it doesn't matter what color the snake is that bites you. The truth of the matter is, it's still a snake. Thank you.
Okay, thank you, Jeffrey. This next question is for you, Joseph. As the legal proxy for the estate, why didn't the public know about this before the election, such as the Lilly Ledbetter and Abigail Fisher cases, which both got national news media coverage? So is there some legal or political reasons why the government is concealing your case from the people?
Well, this case stems back to when it was first authorized by Ronald Reagan in 1988. He authorized the spying program simply based upon the fact that the family was questioning the conduct of judges within the state of Missouri in the probate division and the appellate court and the Missouri Supreme Court. Ronald Reagan in 1988 authorized a spying program against the estate's family members. In 1989, the estate filed an appeal to contest the payment ordered by Judge Brandon Ryan to Julius H. Berg and Associates. At that time, the chief judge of the Missouri Court of Appeals was one James A. Pawlowski. In November of 1989, he denied the state's appeal. Then in 1989, he perpetrated a fraud upon the court by impersonating himself to be a federal magistrate judge. The chief judge of the federal 8th Circuit City of St. Louis Eastern Division at the time was Edward L. Filippini. He authorized a state actor, the chief judge of the Missouri Court of Appeals, to impersonate a federal judge, to where he entered an order against a civil complaint we filed against the United States government relevant to the spying program and against the state of Missouri relevant to the estate deprivation of civil rights. At that time, Chief Judge Edward L. Filippini authorized James A. Pawlowski to implement an order to deny the estate member's complaint, which in fact was a fraud based upon the fact that he authorized a state actor to dismiss a claim against his own employer, the state of Missouri. Okay, in 1991, Judge Jean C. Hamilton, she was the district judge appointed and confirmed by the Supreme United States Senate. At that time, she sat to hear our grievances against Chief Judge Edward L. Filippini and James A. Pawlowski. At that time, she also denied review. After that, we filed for an appeal with the 8th Circuit Court of Appeals. But the coincidence and twist to this was that the same chief judge who authorized James A. Pawlowski to implement a fraud upon the court by impersonating a federal magistrate, he then turned around and impersonated the office of the chief judge of the Court of Appeals. At that time, he denied our appeal of the order of James Hamilton, District Judge, Chief Judge Filippini, and denied review of the state action implemented by James A. Pawlowski. In 1991, the Supreme Court accepted and filed and set for hearing a grievance against the fraud against the court implemented in the lower federal courts. The chief judge at the time was William H. Rehnquist. Clerk William K. Suter filed our complaint. The matter was set for hearing from 1991 to 2005. The matter was never adjudicated to decision by the Supreme Court. The most interesting part about the matter is the then Solicitor General of the United States government, Kenneth R. Starr, he implemented a waiver on December 16, 1991, that he would not contest the allegations raised in the complaint filed and set for hearing by the Supreme Court. But from 1991 to 2005, Chief Justice Rehnquist, one, he had knowledge of the spying based on the Foreign Intelligence Surveillance Act. The Chief Justice, the Director of National Intelligence, and the Attorney General of the United States were privy to all information gathered under the surveillance. But Chief Justice Rehnquist didn't act upon it. Chief Justice Rehnquist, as the supervisor over the federal courts, he knew in 1991 that James A. Pawlowski was not a federal magistrate. Two, he knew that Chief Judge Edward L. Filippini was not the chief judge of the Federal Court of Appeals for the 8th Circuit. In 2005, when Chief Justice John G. Roberts was appointed as Chief Justice of the United States Supreme Court, All matters that was previously pending before his predecessor fell within his jurisdiction. But in 2005, Chief Justice Roberts, he continued the conspiracy against civil rights. He did not order the United States government to cease and desist the spying program. Based upon there is no statute of limitation applicable to fraud upon the court when implemented by the court, the plaintiffs in 2010 filed another claim in the District Court of the 8th Circuit. At this time, Chief Judge Catherine D. Perry, she took it upon herself to assign herself to the case. She subsequently dismissed it as frivolous, citing 28 United States Code 1915. After that, the plaintiffs filed for an appeal with the Court of Appeals of the 8th Circuit. That case was filed under number 11-1088. At that time, the plaintiffs filed for removal pursuant to Supreme Court Rule 11. On March 23, 2011, the Supreme Court for the second time filed the complaint. This time, prior to the matter being adjudicated, Associate Justice Kagan was assigned case number 10-10653 by Chief Justice Roberts. At the point of review by Justice Kagan, subsequently, after the fact, the Missouri Court of Appeals action that we filed in the Court of Appeals, the Court of Appeals on March 25, 2011, they vacated the order of Chief Judge Perry that was entered on December 14, 2010. The Court of Appeals thus remanded. But the only problem with it was that the matters under Johnson et al. Versus United States et al. Was under writ of certiorari to the United States Supreme Court, so therefore the order of the Court of Appeals entered on March 25, 2011 was a moot issue. But prior to Justice Kagan entering her order in her de novo review, Chief Judge Perry, she remanded back to herself and appointed District Judge Sipple to hear Johnson et al. Versus United States et al. At the time was still pending review before Justice Kagan. On June 3, 2011, Judge Sipple dismissed Johnson et al. Versus United States et al. For the second time, citing 28 United States Code 1915, saying that the matter was frivolous. But the fact of the matter is, in June of 2009 and February of 2010, the United States Justice Department executed 2 notifications under the Freedom of Information Act attesting to the fact that the spying program implemented against the plaintiffs was actually ongoing at the time of the proceedings before the Supreme Court and the District Court. At the time of the dismissal by Judge Sipple, subsequently Judge Kagan entered her order on October 11, 2011 to confirm the Court of Appeals order that was entered after the fact on March 25, 2011, which basically means that the Chief Judge of the District Court, Catherine D. Perry, had preempted the Supreme Court's jurisdiction by remanding prior to the court granting and authorizing remanding by the Supreme Court. Judge Sipple's dismissal on June 3, 2011 was a denial of due process because he did not afford the plaintiffs a federal evidentiary hearing as a show cause against the Attorney General of the United States, Eric H. Holder Jr., and the State Attorney General, Chris Koster, to explain to the court why the surveillance against the plaintiffs were continuing for a period over 25 years. Subsequently, the plaintiffs filed suit against Justice Kagan, the Supreme Court justices en banc, which means the entire court. We subsequently sued Chief Judge Catherine D. Perry and Judge Sipple based upon the denial of civil rights and as a conspiracy in a continuing conspiracy in the spying program. Subsequently, District Judge John A. Ross was assigned the plaintiff's civil suit, but on a subsequent date of May 23rd, 2012, he dismissed the case also as being frivolous.
I do understand also that there was a second waiver issued.
Yes, at that time, the current Solicitor General of the United States, at the time Justice Kagan was reviewing her de novo review, the Solicitor General, Donald B. Varelli Jr., he issued a second waiver of defense that he would not contest the matter that Justice Kagan was now reviewing. But Justice Kagan, she did not implement a final decision based upon the fact that she would have to adjudicate the issues as to whether the plaintiffs had the right to a trial by jury of their claim against the United States and the state of Missouri.
Okay. David, as an investigator for this state, is there anything that you would like to add?
Yes, Sherry. Let's first go over my credentials, which are as such. I'm a graduate of the Greater St. Louis Police Academy. I've worked in law enforcement and security for over 29 years. I'm also a graduate of the military's NCO Academy, where I've served as a supervisor on both an active duty and reserve status. I'm also a Vietnam-era vet with an accommodation. I've investigated this probate case for over 24 years, gathering evidence. I've contacted local, state, and federal leaders, advising them of this situation. But no one wants to take a stand because they're afraid that it might affect their political careers. Well, they got to understand that leadership without accountability do not stand in a democracy. We don't intend to give up this situation. We intend to pursue it. We intend in the state of Missouri to start at this point to get rid of all crooked judges and their colleagues and their clerks. People, stand up, start being accountable for your actions. Look into your probate system. Money is disappearing. As we say in the investigative field, just follow the money, and you'll see why this corruption is existing. Join us on our website.
Okay, I'd like to thank the Johnsons for their time. If you would like to contact the Johnsons, you can email them at bigbadbrothers3@gmail.com. Also visit their website at their dirty little secret, usgovconspiracy.com. Thank you.
Thank you.
Thank you, Sheriff.